Companies Act, Section 201, Forms of, and Procedure in relation to, certain applications. Section 201 of the Companies Act, 2013 outlines the formal process and procedural requirements for companies when making applications to the central government under Section 196, which deals with the appointment of managing directors, whole-time directors, and managers, especially in cases of inadequate or no profits. This section is critical in ensuring that such applications follow a prescribed format and procedure to ensure transparency, fairness, and proper communication with the company's members and stakeholders. It includes guidelines on the form of the application, the issuance of notices to members, and the publication of those notices. 1. Form of application. Subsection 1 of Section 201 mandates that any application made by a company to the central government under Section 196 must be submitted in a prescribed form. This form will specify the details that must be included in the application, ensuring that the process is consistent, standardized, and aligned with the regulations set forth under the Companies Act. The purpose of this requirement is to maintain uniformity across all applications and provide a clear and concise format for companies to follow when seeking approval from the central government for appointments or remuneration matters. The prescribed form ensures that the application contains all necessary information, such as the nature of the application, the details of the proposed appointment or remuneration, and any other relevant documents or justifications. By standardizing the process, the Companies Act aims to simplify and streamline the approval process for both companies and regulatory authorities. 2. Procedure for application. Notice to members. A. Issuance of general notice. Subsection 2 of Section 201 provides important procedural requirements that companies must follow before submitting their application to the central government under Section 196. The first step in the process is the issuance of a general notice to the members of the company. This notice must clearly indicate the nature of the application that the company intends to make. The purpose of this requirement is to keep the company's members informed about the decisions or actions that the company plans to take, particularly those related to the appointment or remuneration of directors or other key management personnel. This notice serves as a form of disclosure and ensures that the members are aware of the company's intentions before the application is formally submitted. It gives them an opportunity to understand the proposal and express any concerns or objections they might have. The notice also enhances transparency within the company, fostering trust and engagement among members. B. Publication of the notice. To further ensure that all members are properly notified, subsection 2(b) specifies that the general notice must be published in 2 newspapers. In the principal language of the district where the company's registered office is located, in a newspaper that circulates in that district. In English in a newspaper that circulates in the district, ensuring that both local and broader stakeholders have access to the notice. This dual publication ensures that the notice reaches a wide audience within the company's area of operation, including members who may not be directly involved in the day-to-day affairs of the company. By publishing in both the local language and English, the company ensures that it is accessible to a broad demographic, enhancing inclusivity and ensuring all members are informed, regardless of their language preference. C. Certification and attachment of notice. Once the notice has been published, subsection 2(c) requires the company to attach copies of the notice to the application made to the central government. Along with the copies of the published notices, the company must also include a certificate confirming that the notice was properly published in accordance with the specified guidelines. This certification serves as proof that the company has complied with the notice requirements and provides transparency in the application process. The inclusion of this certification and the published notices in the application assures the central government that the company has made the necessary efforts to inform its members about the proposed appointment or remuneration, in line with the statutory requirements. It also provides a record that the company followed the proper procedure, ensuring compliance with the Companies Act and protecting the interests of the company's members. For more details, contact us.